At 4 o'clock in the morning on March 4th, 1801, John Adams quietly slipped out of the brand new, like, half-built executive mansion in Washington, D.C.
Literally before the sun came up.
Right. Pitch blackout. He climbs into a public stagecoach entirely alone and just begins this long, miserable journey back to Massachusetts.
Fleeing town, basically.
Yeah, exactly. He's abandoning the Capitol hours before his bitter rival, Thomas Jefferson, is scheduled to be inaugurated as the third president of the United States. Adams, I mean, he just couldn't bring himself to attend.
Which is wild to think about today.
It is. He was handing over the country to a man he genuinely believed might, usher in the absolute destruction of the American Republic.
The stakes felt that high to him.
They really did. But before Adams boarded that early morning stagecoach, he spent his final days in office executing this frantic, deeply calculated strategy. He wanted to ensure his defeated political party would maintain, like, a death grip on the one branch of government Jefferson couldn't immediately touch.
And the fallout from that specific desperate strategy, it basically created the defining architecture of the American legal system.
Which is crazy.
Right, because when we look at the immense authority the Supreme Court wields today, the assumption is often that this power was, like, carefully mapped out by the framers at the Constitutional Convention.
Like it was some deliberate philosophical design meant to perfectly balance the government.
Exactly, a neat little blueprint. But the actual historical dossier paints a radically different picture. The bedrock of the court's authority wasn't born from a philosophical consensus. It was forged in a chaotic, high-stakes political panic.
Driven completely by partisan survival.
Totally.
And that brings us to our focus for this deep dive. Welcome, everyone. Today we're looking at a fascinating stack of sources with you. We've got the original legal dossier from Marbury v. Madison, the text of the U.S. Constitution, Alexander Hamilton's Federalist No. 78, and a wealth of historical analysis detailing the visceral political warfare of the early 1800s.
It's a great stack of material.
Yeah, it really is.
Mm-hmm.
And our mission here isn't just to review a landmark case like it's a dusty textbook entry. We want to understand the underlying mechanics with you. How does a cornered Chief Justice manage to, lose a battle over an undelivered piece of paper?
But quietly capture an entire empire of legal authority in the process.
Yes. It was arguably the most brilliant political maneuver in American history.
Without a doubt. And to understand the gravity of that maneuver, we really have to recognize the sheer volatility of the autumn of 1800.
Set the scene for us.
Right. So this was the very first partisan transfer of power in the nation's history. The incumbent Federalists, led by Adams, were facing off against the Jeffersonian Republicans, and the animosity between these two factions.
Oh, man, it makes modern political polarization look incredibly tame by comparison.
It really does. I mean, Federalists had spent the previous years passing the Alien and Sedition Acts, literally throwing Republican newspaper editors into prison just for criticizing the Adams administration.
Just for writing bad things about the president.
Exactly. And Jefferson's camp, they responded by painting Adams as this monarchist who wanted to bring a British-style aristocracy back to America.
It was incredibly toxic, and the election itself was a total nightmare.
An absolute nightmare. Jefferson actually tied in the Electoral College with his own running mate, Aaron Burr.
Which is a whole other crazy story.
Right, but it threw the decision to the House of Representatives, which took 36 agonizing ballots to finally resolve.
36. I mean, imagine the tension.
Oh, the tension was through the roof. During those 36 ballots, governors from Republican states were quietly preparing their state militias to march on Washington if the Federalists tried to, usurp the election.
Wait, literally preparing to march on the Capitol?
Literally, the threat of a second civil war was entirely real. It wasn't just rhetoric.
That is wild.
So when the dust finally settled, the Federalists hadn't just lost the presidency, they had been decimated in the congressional elections as well. They were staring down complete political annihilation.
Okay, so imagine a defeated sports team realizing they've lost the championship, right? And so in the final seconds, they try to sign all the referees to lifetime contracts.
That is actually the perfect analogy, because there is a crucial gap in the calendar here. Even though the election was decided in late 1800 and early 1801, the newly elected Republican Congress and President Jefferson wouldn't actually take office until March 4th.
Right. Inauguration Day used to be way later.
Exactly. So this gives the defeated lame duck Federalist Congress a few fleeting weeks to just, build a fortress.
And the only real estate left for them to occupy is the federal judiciary.
Because federal judges serve for life. If Adams can pack the courts with Federalist loyalists, they can act as a permanent, immovable roadblock against whatever radical agenda they assume Jefferson is planning to roll out.
Okay, so how do they actually do it? What's the mechanism?
The legislative vehicle for this was the Judiciary Act of 1801, which they passed just 3 weeks before Jefferson's inauguration.
3 weeks. Talk about the wire.
Yeah, they were rushing. And it completely overhauled the federal court system. It created 16 new federal circuit judgeships.
Which is a lot of power to just conjure out of thin air.
It is. But it also included this highly strategic, incredibly petty provision regarding the Supreme Court itself.
Oh, I love this part. Tell them what it did.
The act stipulated that when the next Supreme Court justice retired or died, that seat would simply be abolished, reducing the court from 6 justices to 5.
Which is just astonishing. That is an astonishing piece of institutional sabotage. They are structurally shrinking the Supreme Court for the explicit purpose of robbing the incoming president of an appointment.
Yes. They know Jefferson wants to put a Republican on the bench, so they just simply legislate the empty chair out of existence.
It's like, oh, you won the election. Cool. The prize doesn't exist anymore.
Exactly. It was a raw exercise of legislative power to hobble the incoming executive branch, and it didn't stop there. Just days later, Congress passed the District of Columbia Organic Act, which authorized the president to appoint as many justices of the peace for the newly established capital as he saw fit.
As many as he wants. No limit.
No limit. So Adams immediately nominates 42 loyal Federalists for these low-level judicial posts.
Okay, but this brings us to the logistics of the chaos. Because creating 42 new jobs, plus the 16 new circuit judgeships, all in the waning hours of an administration, that requires a massive amount of physical paperwork.
Right, there's no select all approve button.
Exactly. We have to visualize the scene in the State Department on March 2nd and 3rd. There are no word processors, no emails. Every single commission has to be written out by hand.
Dipping a quill in ink.
Yeah, and the president has to physically sign his name to every single document. Then the Secretary of State has to press the Great Seal of the United States into the wax on each parchment.
It's a very physical, mechanical process.
Very. And finally, a last step. Someone has to physically carry that piece of paper on horseback or by carriage and deliver it into the hands of the appointee.
And that mechanical breakdown, the breakdown in that 3-step process, is the catalyst for everything that follows.
Right.
Because Adams is signing these documents up until 9 o'clock at night on his last day in office.
Hence the name Midnight Judges.
Exactly. That's why history remembers them as the Midnight Judges. The State Department clerks are frantically affixing the Great Seal. But in this mad rush to, vacate the offices before the Jefferson administration literally walks in the door the next morning, the final step is neglected.
The delivery.
Delivery. It's just forgotten for a handful of these commissions.
So it's literally flickering candles, desks piled high with papers, and the Federalist administration just packs up its bags, blows out the candles, and leaves town, leaving a stack of signed, sealed, but undelivered lifetime appointments just sitting on a desk.
Just sitting there in the dark.
And one of those forgotten pieces of parchment belongs to a man named William Marbury, a prominent Maryland financier and this staunch Federalist who had been promised a 5-year term as a justice of the peace in Alexandria.
And Marbury's commission becomes the focal point. But, the true irony of this entire situation rests entirely on the identity of the man who failed to deliver it.
Oh, man. This is the best part.
Do you want to do the honors?
Absolutely. The Secretary of State for John Adams, the executive officer whose literal constitutional duty was to ensure those commissions were delivered, was John Marshall.
Right.
And this is where the historical reality just completely bends the mind.
Right.
Because John Adams, during this same lame duck period, had appointed a new Chief Justice of the Supreme Court to replace the ailing Oliver Ellsworth.
He had actually offered it to John Jay first, the very first Chief Justice.
Right, and Jay turned it down.
He did. He turned it down because he felt the court lacked, quote, energy, weight, and dignity.
Which is a sick burn on the Supreme Court. So Adams turns to his Secretary of State, John Marshall, and Marshall accepts.
Which means that for the final month of the Adams administration, John Marshall was simultaneously serving as both the Secretary of State and the Chief Justice of the United States.
Wait, so the guy who is going to eventually rule on whether the government screwed up is the exact same guy who committed the screw-up?
Yes. He was acting in an executive capacity while holding the highest judicial office in the land.
I mean, separation of powers was apparently more of a suggestion in 1801.
It was very fluid, let's say. But the implications for this specific case are just staggering, because John Marshall, the Secretary of State, is the person who created the administrative error by failing to deliver Marbury's commission.
Yeah.
And now John Marshall, the Chief Justice, is going to preside over the Supreme Court case, determining whether his own failure was illegal.
When you lay it out like that, it sounds like an insurmountable conflict of interest. I mean, by modern standards of judicial ethics, a judge must unequivocally recuse themselves if they have personal knowledge of disputed evidentiary facts, or if they served in governmental employment and participated personally and substantially concerning the proceeding. If a case arose today regarding a clerical error, the clerk who committed the error could not subsequently serve as the appellate judge reviewing it.
It would trigger an immediate congressional inquiry today. It would be front-page news everywhere.
Oh, completely. But I guess we have to evaluate Marshall's actions through the lens of early 19th century legal norms, not the 21st century American Bar Association guidelines, right? Did the legal community in 1803 view this as a scandalous conflict?
Well, the ethical landscape was fundamentally different back then. In the English common law tradition, which obviously deeply influenced the early American judiciary, the primary standard for recusal was nemo iudex in causa sua.
Meaning no man should be a judge in his own cause.
Exactly. However, this was overwhelmingly interpreted to mean a direct personal financial interest.
Well, I see.
Yeah, so if ruling one way would directly line the judge's own pockets, recusal was necessary. But mere prior involvement in the administrative background of a case or, political alignment with the parties, that did not automatically mandate recusal.
Interesting. But even factoring in those looser standards, the situation was remarkably tangled, because the historical records suggest that John Marshall's own brother, James Marshall, was in the State Department that night.
He was, yeah.
And James supposedly offered to help carry away some of the commissions, but couldn't physically carry all of them, which is why Marbury's was left behind.
Right, they were literally just carrying stacks of paper.
And later in the Supreme Court proceedings, James Marshall actually submits an affidavit testifying about what he saw in the State Department.
That's true.
So the Chief Justice is presiding over a case caused by his own administrative failure, where his own brother is serving as a key witness to the events. It's like a bad movie plot.
The layers of entanglement are completely undeniable. But, Marshall's refusal to recuse himself points to a larger institutional reality.
What do you mean?
The Supreme Court in 1801 was not the revered, unassailable institution we recognize today. It was fragile. It was operating out of a small, cramped room in the basement of the Capitol building.
Literally, in a basement.
Literally. Marshall recognized that stepping away from this case would hand the narrative entirely to the Jeffersonians. He chose to absorb the ethical awkwardness because he saw an existential threat looming over the judiciary itself.
Right. And that threat materializes the exact moment Thomas Jefferson takes the oath of office. Because Jefferson walks into the executive branch, his people open the desks in the State Department, and they find this stash of undelivered Federalist commissions.
You can just imagine the absolute disgust.
Oh, he must have been furious.
Yeah.
Jefferson views these appointments not as legitimate governmental staffing, but as an insidious attempt by a defeated faction to rule from the grave. The voters had explicitly chosen a new direction, and the Federalists were trying to legally barricade the machinery of government against that mandate.
And Jefferson's response was swift and uncompromising. He instructed his new Secretary of State, James Madison, to treat the undelivered commissions as null and void.
Just ignore them.
Just ignore them. He forbade their delivery. To Jefferson, a commission wasn't valid until it was delivered. If Adams didn't finish the job wasn't finished.
So William Marbury discovers his commission is being held hostage by the new administration, and he decides to fight.
Naturally.
But he doesn't file a lawsuit in a local D.C. court or a federal district court. He takes his grievance directly to the Supreme Court. Marbury petitions the court to issue a writ of mandamus against Secretary of State James Madison.
Right. And we should probably explain what that is.
Please do.
The writ of mandamus is an ancient instrument of English common law. The term roughly translates to "we command." It is an extraordinary court order compelling a government official to perform a mandatory duty correctly.
Okay, so Marbury is asking the judicial branch to reach directly into the executive branch and force a cabinet secretary to hand over a specific piece of paper.
Exactly, which places Chief Justice John Marshall in an incredibly precarious position. Marbury has forced a direct, unavoidable confrontation between the court and the president. And when you analyze the board, Marshall's options are both catastrophic.
I love this part. This is the trap. Marshall is locked in a room where both exit doors are wired to explode. Let's look at the first path. Option A, Marshall rules in favor of his fellow Federalist, William Marbury, and issues the writ of mandamus. What is the immediate consequence?
Well, if Marshall orders Madison to deliver the commission, Jefferson will almost certainly instruct Madison to just ignore the order.
We'll have to say no.
Exactly. Jefferson despised Marshall. I mean, they were distant cousins, but their political and personal hatred was profound.
Thanksgiving must have been awkward.
Very. And Jefferson firmly believed that the executive branch had the right to interpret the Constitution for itself regarding its own duties. If the court issues an order and the president simply scoffs and refuses to comply, the court's fundamental weakness is exposed to the entire world.
Right, because the Supreme Court has no police force.
Exactly. It commands no army. Its power relies entirely on the executive branch enforcing its rulings. If Jefferson calls their bluff, the judiciary is instantly rendered a toothless advisory body.
So issuing the order leads to institutional humiliation. The court proves it cannot enforce its own will. But the alternative path, option B, seems just as destructive. If Marshall recognizes that Jefferson will ignore him, he might decide to back down. He could rule that the court cannot interfere with executive branch business, deny Marbury the commission, and let Jefferson win.
Right, but that path, even though it avoids a direct clash, it exacts a terrible price. It signals to the nation and to the Republican Congress that the Supreme Court is a frightened, subservient institution.
Like a junior branch just bowing to the president.
Exactly. It establishes a precedent that the judiciary will bend the knee to executive power whenever the political stakes are high. It effectively crowns the president as being above the scrutiny of the law.
So it is a perfectly engineered booby trap. If Marshall fights, he loses his authority. If he cowers, he surrenders his independence. How does he get out?
Well, it's even worse than just the trap itself, because we have to factor in the broader political warfare happening simultaneously. The Republican Congress wasn't just sitting by. They were actively dismantling the Federalist judicial fortress.
Right, the 1801 Act.
Yes. In 1802, Congress passed a repeal act that completely erased the Judiciary Act of 1801. They abolished all 16 of those newly created circuit judgeships.
Wow. And that repeal act sparked a massive constitutional crisis of its own, right? Because federal judges are guaranteed life tenure during good behavior under Article 3 of the Constitution.
Yes, and the Federalists argued that Congress couldn't simply fire lifetime judges.
So how did the Republicans get around that?
It was a brilliant, highly semantic maneuver. They claimed they weren't firing the judges. They were merely abolishing the office the judge occupied. If the office no longer exists, there is no job to hold.
Wait. If the Republicans can simply legislate lower federal courts out of existence to purge judges they don't like, what is stopping them from going after the Supreme Court itself?
Literally nothing but the political will to do it. And the Republicans demonstrated just how ruthless they were prepared to be. Because the Federalists were planning to challenge the constitutionality of that repeal act, Congress took a preemptive strike.
What does he do?
They passed another law that altered the Supreme Court schedule, effectively canceling the 1802 term entirely.
Wait, really?
Yes. They forced the Supreme Court to go on a 14-month hiatus simply to prevent them from ruling on the destruction of the lower courts until the Republican changes had time to take root.
That is bonkers. The concept of a modern Congress passing a law to put the Supreme Court in a timeout for a year is unimaginable.
It really highlights how raw and unsettled the American power structure was at that moment. The branches of government were still aggressively testing the boundaries of their authority. The Republicans were sending a very clear message to John Marshall. The legislative branch holds the power of the purse and the power of structure. If you misstep in this Marbury case, we can and will dismantle you.
Okay, so Marshall understands this perfectly. He knows he's cornered. When the Supreme Court finally reconvenes in February 1803, the tension in the Capitol must be suffocating.
Oh, absolutely. Everyone is waiting to see whether Marshall will capitulate to Jefferson or trigger a constitutional crisis by issuing a command the president will ignore.
And this is where Marshall executes his judicial masterstroke. He drafts an opinion that carefully dissects the situation into 3 distinct questions.
And the structure of Marshall's opinion is essential to the trap he is setting for the Jefferson administration.
Because he doesn't begin with the most obvious legal question, which is jurisdiction. Normally, a court must first decide if it even has the authority to hear a case before evaluating the facts.
Right. You establish if you're even in the right room before you start arguing.
But Marshall flips the script. The first question he poses is, does William Marbury have a legal right to the commission he demands?
And Marshall's answer to this is an emphatic yes. He dives deeply into the mechanics of appointment. He argues that once the president has signed the commission and the Secretary of State has affixed the seal, the appointment is complete.
The paperwork is just paperwork.
Exactly. The physical delivery is merely a courtesy, an administrative afterthought. The legal right to the office vested the moment the wax was stamped. Therefore, Marshall concludes, Marbury has a property right to this 5-year appointment, and the Jefferson administration is violating that right by withholding it.
So Marshall is strategically establishing the moral high ground right out of the gate. By affirming Marbury's right, he moves to the second question. If a right has been violated, do the laws of his country afford him a remedy?
And here, Marshall leans heavily on the philosophical foundations of English and American law. He famously writes that the government of the United States has been emphatically termed, quote, a government of laws and not of men.
Which is a great line.
It is. He argues that it is a settled and invariable principle that every right, when withheld, must have a remedy. If the law cannot protect a citizen's vested right against the overreach of the government, then the concept of liberty is an illusion.
And this is where Marshall really turns the knife. Because he doesn't just quietly state that a remedy exists. He uses this section of the ruling to deliver a blistering public reprimand of Thomas Jefferson and James Madison.
He essentially accuses the president of acting like a monarch.
Yes, behaving as if executive power shields him from the basic obligations of the law. He is creating an official public record that the Republican administration is acting lawlessly.
The political theater here is extraordinary. Marshall is building incredible tension. By answering yes to the first 2 questions, he is leading every observer to believe he is about to drop the hammer.
Right. He has declared Marbury is entitled to the commission. He has declared the law demands a remedy. He has thoroughly humiliated the executive branch in writing. The logical next step, the only step that seems to follow, is to issue the writ of mandamus and force the confrontation.
Jefferson's allies are bracing for the collision.
But then Marshall pivots to the third question. And this is the trapdoor opening to meet everyone's feet. Marshall asks, is the specific remedy Marbury is asking for a writ of mandamus issued directly by the Supreme Court, authorized by law?
And to answer this, Marshall forces a meticulous examination of how Marbury's lawsuit actually arrived at the Supreme Court. As we discussed, Marbury bypassed the lower courts entirely. He filed directly in the Supreme Court, invoking what is known as original jurisdiction.
Right. And Marbury did this because a law passed by Congress, Section 13 of the Judiciary Act of 1789, explicitly gave the Supreme Court the authority to issue writs of mandamus to officers of the United States.
So Marbury followed the instructions perfectly. Congress passed a law in 1789 detailing the court's powers. Marbury used that exact law to ask for his remedy. The text of Section 13 seems unambiguously supportive of Marbury's strategy.
But Marshall introduces a massive roadblock by pulling out the Constitution itself.
Right. Marshall directs attention to Article 3, Section 2 of the Constitution, which defines the jurisdiction of the federal courts. The Constitution explicitly divides the Supreme Court's authority into 2 categories: original jurisdiction and appellate jurisdiction.
And just for our listeners, let's clarify that. Original jurisdiction means the Supreme Court is the first court to hear the case.
Exactly. And appellate jurisdiction means the case starts in a lower court and is appealed up to the Supreme Court.
And the Constitution is very specific about which cases fall into the original jurisdiction category. It limits it to cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. That is a very short, closed list. For all other cases, the Constitution dictates the court shall have appellate jurisdiction.
Exactly. So Marshall lays these 2 documents side by side. On one side, you have the Constitution, which says the Supreme Court only has original jurisdiction over ambassadors and states. On the other side, you have Section 13 of the Judiciary Act of 1789, passed by Congress, which attempts to give the Supreme Court original jurisdiction to issue writs of mandamus to government officials like James Madison.
And William Marbury is an angry Maryland banker. He is neither an ambassador nor a state.
Exactly.
The deduction Marshall makes here is devastating. He points out that Congress, through the 1789 Act, attempted to expand the Supreme Court's original jurisdiction beyond the boundaries explicitly drawn by the Constitution. Congress tried to rewrite the rules of the game using a standard piece of legislation.
And this leads to Marshall's inescapable conclusion. When an act of the legislature conflicts with the Constitution, which document prevails?
Think of the Constitution as the ultimate rulebook for a game, right? Congress is the committee that makes day-to-day regulations. What Marshall said was, if the committee makes a regulation that contradicts the ultimate rulebook, the regulation is thrown out.
Yes. Marshall declares that the Constitution is the fundamental paramount law of the nation. An act of the legislature repugnant to the Constitution is void.
Therefore, Section 13 of the Judiciary Act of 1789 is unconstitutional.
Exactly. Because the law Marbury relied upon is unconstitutional, it has no legal force. And without that law, the Supreme Court has no jurisdiction to hear the case.
The brilliance of this maneuver is just breathtaking. Marshall spends the first half of the opinion proving that Marbury is right and Jefferson is acting illegally. But in the final moments, he throws his hands up and says, unfortunately, the Constitution forbids this court from doing anything about it.
Sorry, my hands are tied.
Exactly. So Marbury loses his commission, the case is dismissed.
And by dismissing the case on jurisdictional grounds, Marshall entirely diffuses the immediate political crisis. He denies Marbury the commission, which gives Thomas Jefferson exactly the outcome he demanded.
Jefferson has nothing to defy. The administration won the lawsuit.
They did. But the rationale Marshall uses to hand Jefferson that victory fundamentally alters the power structure of the United States government forever.
By striking down Section 13, Marshall successfully establishes the precedent that the Supreme Court has the authority to declare an act of Congress unconstitutional. He weaponizes a tactical retreat. He limits the court's jurisdiction in this one specific instance in order to claim an infinitely broader, permanent power over the legislative branch.
Yes. This power is known as judicial review, and Marshall cements it with language that has become the absolute bedrock of American constitutional law. Quote, "It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each."
It is a sweeping, definitive declaration of supremacy in legal interpretation. But the sources we are reviewing today highlight a profound historical debate surrounding this moment. Was John Marshall inventing this power out of thin air to save his institution? Or was he merely articulating a truth that was already baked into the DNA of a written constitution?
And we should look at both sides of that impartially, because the textualist critique of Marbury v. Madison is quite severe.
Extremely severe. Tell us about it.
So critics, both historical and modern, point out that the text of the United States Constitution never explicitly grants the Supreme Court the power to strike down legislation.
You can read the whole thing, and it's not there.
You can scour the document, and you will not find the phrase judicial review. The framers certainly debated the concept. Some delegates at the convention favored a council of revision where judges and the executive would jointly veto laws, but that was rejected.
Oh, wow. So they actually voted it down.
They did. So the fact that such a monumental power is entirely absent from the explicit text suggests to some that it was never intended to be an absolute, unreviewable authority held solely by the courts.
Beyond the lack of explicit constitutional text, legal scholars often point out the aggressive legal gymnastics Marshall had to perform just to force this conflict in the first place. Let's consider how a judge practicing judicial restraint might have read Section 13 of the 1789 Act.
That is a crucial point of analysis, because a restrained judge could easily have interpreted Section 13 differently.
How so?
Well, the statute said the court had the power to issue writs of mandamus in cases warranted by the principles and usages of law. A judge could argue that Congress simply meant the court could issue the writ in cases where it already had proper jurisdiction.
Meaning in appellate cases.
Exactly. If Marshall had interpreted the statute that way, there would have been no conflict with Article 3 of the Constitution.
Oh, I see. Section 13 would survive. The court would simply inform Marbury he filed in the wrong court, and the case would be dismissed without any grand constitutional declarations.
Precisely. The fact that Marshall chose the most expansive, conflict-inducing interpretation of Section 13 suggests he was actively hunting for a reason to strike the law down.
He manipulated the statutory interpretation specifically to engineer a platform to announce the power of judicial review.
Right. From that perspective, it looks very much like a deliberate, politically motivated power grab dressed up in the language of constitutional necessity.
That is the argument for invention. But we must weigh it against the opposing view, that Marshall merely recognized and formalized a power that was always logically required by the existence of a written constitution.
And the intellectual foundation for this view was heavily laid by Alexander Hamilton years before Marshall even took the bench.
Yes. If we look closely at Federalist Number 78, written in 1788 during the ratification debates, Hamilton essentially outlines the exact logic Marshall would later use in Marbury.
Hamilton's foresight in Federalist 78 is just remarkable. He was trying to alleviate fears that the proposed federal judiciary would become tyrannical. He famously called the judiciary the least dangerous branch because it had no influence over either the sword or the purse.
Right, it had neither force nor will, but merely judgment.
Exactly. But Hamilton directly addressed the question of legislative supremacy. He wrote that a constitution is, in fact, a fundamental law. If a legislative act contradicts that fundamental law, the courts must regard the Constitution as superior.
Hamilton argued that without the courts acting as an intermediate body between the people and the legislature, Congress could essentially rewrite the Constitution whenever it wanted, simply by passing a new law.
If the legislature is the sole judge of its own constitutional boundaries, those boundaries are meaningless.
Exactly. The logic Marshall adopted. And Hamilton wasn't operating in an intellectual vacuum either. The concept of courts voiding laws had roots in English common law, like Lord Coke's ruling in Dr. Bonham's case in 1610, which suggested common law could control acts of Parliament.
Yes. And moreover, in the years following the Revolution, several state Supreme Courts had asserted the power to strike down unconstitutional state laws. The idea was hovering in the legal atmosphere.
So Marshall's genius wasn't necessarily inventing the concept out of whole cloth. His genius was seizing the perfect, unassailable moment to cement it into the federal system.
That's a great way to put it. He used Jefferson's own political momentum to secure the judiciary's supremacy.
Jefferson wanted Marbury's claim dismissed. Marshall dismissed it, but attached a philosophical writer to the dismissal that declared, "By the way, we are the ultimate arbiters of the Constitution."
It is the ultimate jujitsu move.
It really is. Jefferson won the skirmish over a minor appointment, but he lost the broader war regarding who gets the final say on American law.
And Jefferson realized exactly what Marshall had done. He was infuriated by the ruling. He recognized that Marshall had used a manufactured dispute to assert a power that made the judiciary a co-equal, if not superior, branch of government in matters of constitutional interpretation.
He must have been fuming.
He complained bitterly for years that Marshall had turned the Constitution into a mere thing of wax, which the judiciary could twist and shape into any form they pleased.
Yet, despite Jefferson's fury, the precedent was set. The Supreme Court had claimed the power to invalidate acts of Congress. But the fascinating postscript to this story, a detail that truly contextualizes the fragility of the early court, is what happened next.
This is one of my favorite historical details.
Because Marshall claims this monumental superpower in 1803. You would expect the court to immediately begin wielding it, striking down Republican legislation left and right to protect Federalist interests.
But they don't. The historical reality is that judicial review, as established in Marbury, was a dormant weapon. It was a sleeping power. Do you know how much time passed before the Supreme Court struck down another federal statute?
Given the intense political battles over the national bank and slavery in the early 19th century, you would think it would happen within a decade.
It took 54 years.
54 years.
The Supreme Court did not use the power of judicial review to invalidate another act of Congress until the infamous Dred Scott v. Sanford decision in 1857, when Chief Justice Roger Taney struck down the Missouri Compromise.
Half a century. They build this ultimate weapon, they demonstrate it to the world, and then they lock it away in a vault for 54 years. Why the reluctance? Why claim a power if you aren't going to use it?
Because John Marshall was a brilliant political pragmatist. He understood the difference between establishing a theoretical boundary and actually trying to enforce it against a hostile political majority.
So he knew the court was still too weak to actually fight those battles.
Exactly. The judiciary remained the weakest branch. If Marshall had aggressively used judicial review to dismantle Jeffersonian or Jacksonian legislation in the subsequent decades, the legislative and executive branches would have united to crush the court.
They would have impeached the justices, stripped their jurisdiction, or packed the bench.
Marshall asserted the power in a case where the executive had nothing to defy, establishing the principle for future generations. He planted the flag, but he was incredibly careful not to provoke a war he knew the court could not survive.
He understood that institutional authority requires patience. You claim the ground long before you build a castle on it. It took generations for the culture of the United States to fully internalize the idea that the Supreme Court's interpretation of the Constitution is final.
And the Marbury decision allowed the court to survive its most vulnerable period. By the time the power was wielded again in 1857, the institution of the Supreme Court had grown deeply embedded in the American political psyche.
Judicial review had shifted from a radical, contested assertion into an accepted, fundamental mechanism of the Republic.
Exactly.
When we pull back and look at the entirety of the dossier we've examined today, it forces a profound reassessment of how American governance was actually built. We often hold on to this sanitized vision of the framers, constructing a flawless mechanism of checks and balances in a moment of pure, dispassionate foresight.
Yeah, we like to think of them as philosophers in a pristine room, but the reality is infinitely more complex and, frankly, more human. The defining pillar of the judicial branch was not a gift from the Constitutional Convention. It was the byproduct of partisan warfare.
It required a bitter election, a lame duck strategy, a frantic night of administrative failures, and a Chief Justice willing to navigate a severe conflict of interest to protect his institution from annihilation.
Politics did not corrupt the founding of the modern Supreme Court. Politics provided the very friction required to build it. The system we rely on today to settle our most fundamental disputes is the result of ambitious, flawed men fighting for leverage and accidentally forging constitutional bedrock in the heat of the moment.
It serves as a necessary lens for understanding any institutional power. It forces us to ask critical questions about the nature of authority and how it is legitimized over time.
Which leaves us with a fascinating, almost unsettling thought to consider long after this deep dive ends.
What was that?
If the Supreme Court's most foundational power, the unassailable authority to strike down the laws of the nation, was cemented not by clear constitutional text, but by a strategic, politically motivated escape act designed to save a cornered institution, what other absolute truths of our government are merely the echoes of forgotten political panic?
Wow. What other unquestionable rules of the game were actually just desperate chess moves, waiting for someone bold enough to challenge them? That is incredibly potent. Thank you for joining us as we explored the hidden machinery of American history with you. Keep questioning the structures around you. They are rarely as permanent as they appear.